Good afternoon. This is Jen, the Liberty Lion, and it's Friday, the 22nd of April, 2022. I've posted a lot of videos here in the last couple days. I did them on my phone because I didn't have proper internet in the house, so I used my cellular. Some people would say that it's better to post videos that are high quality videos. I disagree. I rather just post the information rather than worry about the quality of the video, because it's the information that I'm interested and most concerned with, and not so much the quality of the video. But in this video, I want to go over a few things, several that I spoke of in my last video. And I want to talk to you about a ruling that was made on Monday by a federal judge in Florida, and how that correlates with some of the information that I've been giving you. And I'm going to show you why the judge is right in making this decision, and why the CDC has no authority to force people to wear masks or get a vaccination, and why many of these government instrumentalities, in fact, have no authority. So today, I watched a video by a man named the Gsa Manual. I'm probably saying that wrong, but here he is. It's his name is Ken Wheeler, and this is Valuable Life Lesson. And he talked in this video about the truth and debate. And the truth, and this is just a summary in my words of what I believe he's saying, is that the truth is what is most important. Opinions are often not the truth, so truth seekers, even when they're wrong, if they're pointed in the right direction, they're appreciative of the fact that they were proven wrong, because a truth seeker doesn't ever want to waste time being on the wrong path. At least that's how I feel about it. So whenever I'm pointed into the proper direction, I'm appreciative of that fact. And so he's saying that debates aren't always about winning, that a truth seeker in a debate just wants to find the truth of a matter. This is also stated in ancient philosophical text by a lot of well-known philosophers. So debate is merely a fact-finding mission. That truth seekers love the truth even when they're wrong, and it's about the facts. It's about logic, and it's about wisdom. So then I watched a video by Andrew Napolitano, and again, I'm saying this as close to what he's saying as I possibly can, but there may be variations a little bit, so this is not a direct quote. He says the title of his video is "Doctors Who Don't Like Lawyers." And he's naming it this because the doctors are saying you have to wear a mask, and the lawyers are saying actually they don't. And there's no authority doctors have to force people to wear a mask, and that pisses the doctors off. So he's saying the decision was made Monday by a federal judge in Florida who provided an injunction preventing the CDC from ordering all entities regulated by the federal government to require wearing masks by their employees, customers, and clients. And then he said, stated differently, this judge found that the CDC is without authority to compel wearing masks on any, and he calls it entity, that is owned or regulated by the federal government. So an entity is like an instrumentality. I find it odd that he didn't use instrumentality, but maybe he was just trying to keep it simple so that people wouldn't get hung up on words like instrumentality. So anything that the government regulates or owns does not have the authority to force people to wear masks. Okay? Furthermore, it's not in the Constitution. There's no constitutional authority to force people to wear masks. And we can see this in one of the GSA manuals, which is the Government Services Administration Manual. And the Government Services Manual is the manual that provides for the military. So they hire people who work as contractors for the military, and they're called instrumentalities or businesses. And some of these businesses are created by the federal government. But let's look real quick what Ron Paul said on the face of his video that he posted today. Repeal 1913 is the name of the video, in the income tax and the Federal Reserve at the same time. So, quote, "What we really need to do is repeal 1913. That way we could get rid of the income tax and the Federal Reserve at the same time," end quote, Dr. Ron Paul. So this statement, in my opinion, is a little misleading, because it's sort of alluding to the idea that the Act of 1913 had any authority over people not a part of the federal government. Whereas the things that I show you all indicate, and in my mind show proof, that the federal government only has power and authority on the federal lands. And that is also in the Constitution, and I talk about that regularly also. So I'm going to move now to the GSA manual. This is the inventory report. This inventory report of 1962 was written in response to a report done during the Eisenhower administration and ordered by Eisenhower when he was president. Lands are very, very important when it comes to any matter. Where you have the right to do the land is 90% of the case, maybe even 100% of the case, because rights are always attached to land. That's ancient. That goes back for thousands of years. The founders who wrote the Constitution knew this. And so they knew they had to make sure that it had its own lands to do its own things, to make its own laws on. That is a requirement. And so when people read the Constitution, they get a feeling of emotion, and they feel like this Constitution creates a country, it creates a nation, it's over all the land, etc., and so forth. Whereas there are several places within the Constitution that it says exactly the opposite of that. The Constitution lays out specific places for the federal government to do its work. And it does that work in order to keep safe and protect the non-federal lands, the lands that it doesn't own, that are the nation, that all combined make up the nation. And we see that in the preamble. For example, we the people of the United States, meaning the people of the federal lands, that they're going to do things that bring these things forward. So these are their goals for the people not on federal lands. That doesn't mean that everything in the Constitution applies to the people off the federal lands. It means that they derive a benefit when the federal government does its work on the federal lands. You see here it says for. So the federal government does these things for the people not on federal lands. So because during the Lincoln era, during the Civil War, Lincoln did a lot of bad things. He might have done one thing good, which was to sign the Emancipation Proclamation, or to at least bring it forward so that it could be realized and that the slaves could be actually legally, lawfully free. A lot of things happened during that time. And so this propaganda machine started pumping out all this information, all these lies, so that people would believe that the federal government was over all the lands and all the states, that it was the top lawmaker, and the states came under it, and the states had to abide by it, and the states had to do what they were told if the federal government told it to do something. This is not true. The states always have been over the federal government. But the land issue became very muddy. People didn't understand what was the federal lands and what was not the federal lands. Who were the public people and who were not the public people. Who were servants or subject and who were sovereign. And so today we believe that the government is the sovereign entity, whereas it only has some very, very tiny sovereign rights. And the people, because they create government and are creators, they retain all the sovereignty. And they have a right to withdraw that sovereign power. There's an ancient law in a book of legal maxims that says, a power not delegated cannot be delegated. So when the federal government is not given the power to do a thing, it cannot just take the power to do it or pretend that someone else has the power to do it, or they can't take the power that they were given and then give it to someone else. So everything is attached to land. Land is of the utmost importance. And we see this in Section 8 under Article 1 of the Constitution. The original Constitution does not have clauses in it. And so even though this has a 1 right here, and this has a 2 and a 3, and so on and so forth, these numbers do not appear in the Constitution. It will say Section 8 under Article 1, but it won't have the clause numbers. Knowing that helps us understand that Section 8 is one complete sentence. You see, there are no periods in Section 8. So when you go down to the bottom of what we call Clause 19, there is finally a period, and this is the end of this section. They do this, and they did this in the old days often, because this is a list of things, and the list of things are all attached to one another. It can't be picked apart. So if your rights to do things are attached to the land, then it's attaching all of these rights that it has. The Congress shall have the power to lay and collect taxes, duties, impose excises, etc., and so forth, until you get to 17, where it states the lands that it has the right to do these things, which are the seat of government, called Washington, D.C., and the places purchased for the erection of forts, magazines, arsenals, and dockyards, and other needful buildings. Together, these things are commonly known as forts and posts. Okay, so we go up here to posts to establish post offices and post roads. So most people believe this is the United States Postal Service, and that the government had the right to establish a United States Postal Office for everyone to use, where in fact these are simply offices on a military post and roads on a military post. Okay, so the military posts are the military areas. They're called posts. The fact that we have a federal mail system probably was intended to be used by only the federal people, but when we use it, we pay for it by purchasing stamps, whereas the federal government is not required to use stamps for its correspondence. So here we see a list of rights that it's proposing as a contract to the states to let the states know, if you sell us the land and we properly purchase it, these are the things we want to do on the lands. Some states said, sure, okay, sounds good, let's leave it at that. But the states had to pass legislation telling the federal government and the people of the state, first, what lands it was selling to the federal government for the erection of forts, and what jurisdictions it was ceding to the federal government and which jurisdictions it was keeping. So this word jurisdiction may be confusing to some people, but jurisdiction just means your power or your authority. So the states had to specify which powers it was going to give to the federal government. Most states ceded all these things because these things, as the federal government believes, are intrinsic to the military. And so the states were supposed to not interfere with the things going on that the military was doing on the various posts or federal lands. So while the states did this, some states reserved some rights to do some things on the federal lands. So for example, some states wanted the right to serve process on the federal lands. Some states did not reserve the right to serve process on federal lands. And so there are laws written out on how the processes would be either served on the federal lands or how the federal people would serve process on federal people on the federal lands when the state has a process to be served to a person on federal lands. So if a man owes child support and he goes onto a military post and the state can't serve him process, then the mother and the children are not receiving justice. So the federal government cannot hinder justice. It has to provide for it. It has to allow for justice to be served. And so a military officer or a military person hiding out on federal lands so that he doesn't have to pay child support is a hindrance of justice. It's not serving justice to the wife and the child. And so these serving of processes have to be worked out. So the federal government has to agree to serve process over the people on the federal lands, or the federal government has to agree that the state has reserved the right to send its sheriffs or marshals or whoever onto the federal lands, and those people would be allowed onto the federal lands to directly serve the process to that person that they're looking for. In other words, the federal lands cannot be a safe haven for criminals. And this is justice. This is also called comity, C-O-M-I-T-Y, which simply means the respect of other people's power. So when the state reserves its right to serve process, the federal government is in comity or in harmony with the state, allowing for justice to be served. They're respecting the state's jurisdiction to serve process on the federal lands. If the state does not reserve the right to serve process on the federal lands, comity or respect of jurisdiction can be carried out by the federal government for the state. So then the federal government would bring in a military policeman or some other person to receive the process from the sheriff and then go and serve that process themselves on that federal person on the federal lands. This allows for justice. So getting back to the land issue, what we have during the Eisenhower administration is Eisenhower, who had been a general in the military, understood the distinction between military, the federal lands, the Constitution, and everything not a part of that. So what I've been telling people is my experience and my knowledge is that the time I spent in the military and working as a civil servant taught me that the Constitution applies only on the federal lands. There are very, very few minor small things that nobody should ever even be aware of that happen between the state and the federal government. The people of the state should not really even be a part of it. So, inventory report was in response to Eisenhower's jurisdiction over federal areas within the state. A report started in 1953, Part 1 completed in 1956, and Part 2 completed in 1957. I have both of these parts available on archive.org, so you can search them and find them there, or you can look them up on the internet in some search engine, but I will also post them in the description. So Eisenhower's report, the thing I want you to take from this is that the federal lands were, quote, islands in the state. So the federal lands were annexed to the federal government for the use of military, because the Constitution is, and almost only is, the creation of a military power to protect all the free, sovereign, and independent states. That's why this report is called Jurisdiction over Federal Areas within the States. As a response to this, one of the things Eisenhower required was that a report be put out, and this report was to include all the federal areas inside the state, because after Lincoln and all of his stuff that he did, there was a lot of confusion as to what lands the federal government owned, what lands the federal government was given, and what lands the federal government used but didn't actually have jurisdiction over. So this report was put out to help employees of the federal government understand what power they had and where they had it. This report was put out in 1962. It was for the General Services Administration. Here it says, "Dear Mr. President," and in 1962, that was either Eisenhower or Kennedy. I don't recall exactly what year Eisenhower retired. It says, "General Services Administration has completed the second comprehensive inventory of the jurisdictional status of federal areas within the states. The compilation of this inventory reflects the interest which GSA, together with the Bureau of the Budget and the Department of Justice, have in the progress being made by all federal agencies in adjusting the legislative status of their properties." So who can make laws for the property, and what law can they make? What jurisdiction did the state give up to the federal government, and what powers did they retain for themselves over the federal areas? They didn't know. By 1962, they were confused about it. This inventory, which is enclosed herewith, directly complements the inventory report on real property owned by the United States throughout the world as of June 30th, 1962, which was also published by GSA. The inventory will be made available to public agencies and state governments for the use as a ready reference to assist in the solution of jurisdictional status problems. So they admit they're having problems with what power they have and where they have it. And in this development of appropriate remedial legislation, S 815 and HR 4433, pending before Congress, would facilitate the adjustment of legislative jurisdiction over federal areas within the states. Properties are listed by state, county, and holding agency. Street addresses are given, but cities are identified by code only. City names may be determined from the GSA publication, quote, Geographical Location Codes, end quote. A supplement at the end of each state shows the counties covered by each multi-county installation included in the listing, but no breakdown of acreage by county is given. So here we have a paper that may seem a little bit confusing, but I'm going to explain it to you. This is called legislative jurisdiction over federal areas within the states. Now, again, I bring you back to Judge Napolitano's video today, where a judge in Florida said that the CDC has no authority to regulate or control the wearing of masks by their employees, customers, and clients, to which the judge stated differently. This judge, meaning the judge in Florida, found that the CDC is without authority to compel wearing masks on any entity that is owned or regulated by the federal government. This statement is more profound than at first glance. First, you might say, okay, we don't have to wear masks, but actually, no entity has any authority over any corporation or any land not owned with exclusive legislative jurisdiction. Okay, so no entity of the federal government, and the federal government has no authority to regulate anything not part of its exclusive legislative jurisdiction. So the federal government, according to the Constitution, as I've shown you, has power and authority on the federal lands. Those federal people, mostly officers and some civilian employees, signed a contract and work, and some live on the federal lands, which are the military posts, according to the Constitution. Over those posts, Congress has the right to make the laws, to regulate the forces, to make rules, and so on and so forth. Which means they can tax those people, and they can regulate the things that they can bring on post, and they can regulate the things that they take off post. They can tax the private property coming onto the post, and they can tax the private property going off of the post. They can tax the pay of the people on the post. So those people on the military post derive a benefit. For example, they receive housing and they receive health benefits. They also receive use of the roads on post and many other things. So they pay a tax because they have a direct benefit from being on the post. State people do not work on post. The common people do not work on post, and yet we pay a federal tax. That federal tax is applied outside the Constitution, much the same way that the CDC has given itself the right to regulate people not on military posts and not doing business with the government. So the CDC has tried to give itself the authority through the media and through propaganda to make everyone believe that it has the power to put out orders to force people to do something. The CDC has no power. Even if the CDC was on federal lands, it still would have no power over people off federal lands. So let's look at the types of legislative jurisdiction. Code 1. These codes are important. They tell the people in government quickly and accurately what legislative jurisdiction or what lawmaking power it has over areas that it controls. Code 1 is exclusive legislative jurisdiction. So exclusive legislative jurisdiction would include those places in the Constitution under Article 1, Section 8, Clause 17. And those places are the seat of government and the military post called forts, arsenals, dockyards, etc. Now, in order to gain these lands, the federal government had to ask the state if they could purchase the lands. The state had to take a vote of its people, asking its people if it can let the federal government purchase the lands. The reason why they had to do a vote was because the state was never given the authority to arbitrarily join unions. And so a delegated power cannot be delegated to someone else. A power not delegated by the people, who are the ultimate sovereigns in this country, those powers not delegated cannot just be usurped. So there had to be a vote so that the federal government could acquire an authority directly from the people. So it says, this term is applied when the federal government possesses, by whichever method acquired, all the authority of the state, and in which the state concerned has not reserved to itself the right to exercise any of the authority concurrently with the United States, except for the right to serve civil and criminal process in the area for activities which occurred outside the area. So what this is saying is, first of all, we have to agree that the state has the ultimate authority. The state has the ultimate authority to sell lands to the federal government. It has the authority, the right to reserve some lawmaking power over those lands, or to not reserve any lawmaking power over those lands. For example, Fort Leavenworth reserved all rights over the federal lands. Kansas reserved all rights over the post called Fort Leavenworth and the other post in Kansas. Kansas did not give up all right and authority over the federal lands in Kansas, which are built posts. However, the state has agreed not to interfere with military functions occurring on the military post. So it says some states reserve the right to serve criminal process in the federal area for activities which occurred outside the area. So if a military person comes off the federal lands and commits a crime, the federal government has agreed not to harbor fugitives from law and to serve justice. So the federal government has agreed that either the state will be able to serve process directly or that it would serve process for the state on the federal lands. Federal lands are sometimes called area. They're called enclaves, islands, military reservations, forts, arsenals, dockyards, and many other things. So under Code 2, we have concurrent legislative jurisdiction. This term is applied in those instances wherein, in granting to the United States authority which would otherwise amount to exclusive legislative jurisdiction over an area, the state concerned has reserved to itself the right to exercise, concurrently with the United States, all of the same authority. So this is such as Kansas reserving all authority over those federal areas so that it can regulate the federal areas, whereas some states did not reserve any authority, and so they have not concurrent legislative jurisdiction over the federal areas. Code 3, partial legislative jurisdiction. This term is applied in those instances wherein the federal government has been granted for exercise by it over an area in a state certain of the state's authority, but where the state concerned has reserved to itself the right to exercise by itself or concurrently with the United States other authority constituting more than merely the right to serve civil or criminal process in the area. So you have exclusive, where the state has the right to the right to exercise any of the authority concurrently with the United States except the right. Okay, so under exclusive legislative jurisdiction, the state reserves its right only to serve criminal process. Concurrent legislative jurisdiction means that the state reserved equal right over the federal areas, and partial legislative jurisdiction means it reserved to itself a little bit more power and authority over the federal area, more than just the right to serve civil process, but not all rights, so not concurrent. Then we have 4, proprietorial interest only. This term is applied to those instances wherein the federal government has acquired some right or title to an area in a state, but has not obtained any measure of the state's authority over the area. In applying this definition, recognition should be given to the fact that the United States, by virtue of its functions and authority under various provisions of the Constitution, has many powers and immunities not possessed by ordinary landholders with respect to areas in which it acquires an interest, and of the further fact that all its properties and functions are held or performed in a governmental rather than a proprietorial capacity. So what I believe this section is saying is that when it acquires proprietorial interest only, it's really only having the same power that a regular landowner would have. Now, it's saying it's still performing in a governmental rather than a proprietorial capacity, but if it had more than that, more than proprietorial interest only, it would have a right to exclusive legislative jurisdiction. So when it purchased these lands, it didn't purchase them for forts. It purchased them for some other purpose, and so it wasn't exactly given exclusive legislative jurisdiction. It was given some sort of governmental or extra legislative jurisdiction, but they're calling it proprietorial interest only. And then Code 5, unknown. Land will be reported under this category when there is no data or record to guide the reporting holding agency. So because a lot of land was just stolen by the Lincoln administration during the Civil War, and the railroads, and everything in the South was basically decimated. The land was available for people to just come in and take, like the corporations, the railroads who wanted that land without having to actually pay for it. So some of these lands were acquired in some kind of way that they don't really know now during this inventory report how they came about having these lands. So either they're hiding the records because they don't want to know how bad it was, and they don't want to admit that they stole land from the very people they were bound to protect, or they really just have no record. Explanation. The number 1 through 5 appearing in the jurisdictional code column indicates the legislative jurisdiction of the acreage listed on the same line in the land columns. For example, a number 1 indicates exclusive jurisdiction by the federal government over the area shown in the land column on the same line. When we go over here, we see citation to legislative authority. For land areas reporting under exclusive, concurrent, or partial legislative jurisdiction, a general or specific state statute or law, statutes at law, is cited. So the states have on their law books what jurisdiction it ceded over what lands that the federal government has purchased. State statute. Citations to state laws are in the terms of session statutes, regardless of whether or not they have been codified. Each citation shows 1. The year of enactment of the cited statute, 2. The page number of the volume of state laws, and 3. The chapter or equivalent number of the state law. Federal law, statutes at large. Citations to federal laws are shown in cases where legislative jurisdiction was obtained by a reservation and the enabling act authorizing statehood. In my book, Chambers Etymological Dictionary, the most recent one, says that statehood was a word that was created and first used in 1868. 1868 was the end of the Civil War. These citations show volumes and page numbers of the statutes at large. I bring this word statehood up, because statehood seems to appear to have brought the states under the federal government by force, by an usurpation of power by Lincoln acting outside the Constitution. If he was acting in accordance with his oath and with his constitutional office, he would never have been able to do that, not legally. Acceptance for recordation date. This date represents the month, day, and year which the federal government accepted legislative jurisdiction. This date is called for in the case of any acquisition, which is the purchase, after January 31, 1940, Section 355, Revised Statutes, U.S., as well as acquisitions prior thereto where recordation or other affirmative act was required by the application or applicable state statutes. In negligible, an N shown in the land area columns indicates less than 1/10 of an acre. R reference, and R shown in the state statute column indicates that additional unpublished data is on file at the central office of GSA. X, an X shown in the jurisdictional code columns and or the federal law columns indicates that the property of the code and or law cited is considered doubtful by the reporting agency. These listings have been carefully prepared and checked, but perfection cannot be assured. So still they're saying they don't actually know for fact what areas of land they own and what areas of land they don't own. So when we look at things like the U.S. codes. If you search through here on this website, it will show you some land that the government acquired, not purchased, but acquired, received as like a gift from Rockefeller. This land is located in Maryland, and this land was used as, I believe, a medical laboratory or research facility. All the jurisdiction that Rockefeller had, all the power he had, was also ceded to the federal government, allowing the federal government to basically do whatever they wanted on Rockefeller's land. So this was one way that Rockefeller used to get control over institutions such as colleges. He would offer them a donation of money to build laboratories, but then along with that money, he would stipulate that they would have to do a thing. So then we come to the progressives, who often did the same thing and stipulated to the colleges and universities the use of progressive textbooks. This is how we came to having the medical license. The medical license is a requirement because it was a stipulation that Rockefeller put on the donations that he gave to the colleges. So in order that they could have the donation, they went ahead and stipulated that the doctors had to have the license. And along with this problem comes the issue of what is a state and what is not a state. Often it is not defined, and it is not defined in almost anywhere in a way that could be used for all written places. So in any code, this definition would apply. For the Constitution, this definition would apply. For anything, this certain definition on state would apply. Certain titles or certain codes would define state in a different way. And so there are many uses for the word state. There can only be one definition, but there are many uses. So one way that the federal government was able to acquire lands with the various jurisdictional codes or statuses or legislative jurisdictions or powers over those lands was to receive donated lands from wealthy people, or to receive donated lands after Lincoln took over the states, or to just take lands because people believed that the federal government basically could do what it wanted. So on these lands, they built things that had nothing to do with the military. They started building banks, they started building federal buildings, they started putting federal people, federal employees inside these federal buildings. These federal employees have no authority, the buildings have no authority, and the lands came with no authority. So places like the CDC and the people who work in them have no authority, just as Napolitano said. The FDA has no authority, the CDC has none, the CIA has none, the banks have none, and in many cases, the IRS has none. The IRS, when it applies certain titles to people off federal lands, not working for the federal government, has no authority to do that. It doesn't have authority to apply federal laws to non-federal people off federal lands. It does so by usurpation of power, just as the CDC tried to when it mandated people wear masks. And the federal judge in Florida made the correct decision. Now, some people will say, why aren't people taking to the streets? Why aren't they going out and marching? Why aren't they tearing these buildings down? My answer is that you don't need to. All you need to do is understand. You need to understand the lies that they're telling, the propaganda. You need to understand the difference between the fact that federal lands come with federal power, and anything off federal lands, even if it looks like a federal land, has no power, such as the CDC. The CDC is located on land where power was not ceded, or only small portions of power was ceded, such as under proprietorial interest only. Some of these lands may have been donated by wealthy elite people. They are purchasing the lands, donating it to the federal government, building a building on it, calling itself a CDC, allowing itself to be chartered with and regulated by the federal government so that it appears to have federal power and federal backing, whereas the federal government has no actual constitutional power to do these kinds of things. A lot of people will try to convince you that they do, and that the Constitution in some sort of misconstrued way allows these CDCs and FDAs and FBIs and CIAs and Homeland Security and all these other things not part of the military have some sort of power and authority over you, not on federal land, to force you into doing things. And again, as we see by the Florida judge's decision, they have none. Such as what Andrew Napolitano said, authority to compel wearing masks on any entity that is owned or regulated by the federal government. The judge found the CDC is without authority, and it's the same for every single institution, every single corporation, every single organization not on a military post or at the seat of government. And even then, we have to ask, is this for a military purpose, which is the purpose in the Constitution, or is it not? And if it's not, even if it's on federal lands, it has no authority over the people off federal lands. Eisenhower knew this because Eisenhower was in the military. Now, a lot of people are emotionally attached to the Bill of Rights. Again, the Bill of Rights applies to the people on the federal lands because they need to be able to tell on the federal government when the federal government is doing something wrong. And they would know because they're within it. They're within the federal government. They're doing federal works and they're on the federal lands, and they should suffer no repercussion. This is the first and most basic sort of tattleteller law. I forget what Ron Paul calls it, allowing people to come forward with information, people who work with the government to come forward with information to let people off post know what's going on post, to let people outside the seat of government know what exactly is going on at the seat of government. So this inventory report on jurisdictional status of federal areas within the states as of June 1962 is the second comprehensive inventory of its nature ever undertaken. It has been prepared and issued by General Services Administration pursuant to the authority contained in the Federal Property and Administrative Services Act of 1949 as amended. Background: the compilation of the original inventory as of June 30th, 1957, and that's when the jurisdiction over federal areas within the states, that's when Part 2 came out, 1957. So this is the response to the 1956 and 1957 inventory reports. The jurisdiction over federal areas in the state report came out where Eisenhower said we need to do an inventory over all the lands that the federal government actually owns, because in the Constitution, the federal government was given the right to have a seat of government and the right to buy lands to put posts on for military purposes to protect the United States of America, because the federal government, called United States, works for the United States of America. Eisenhower knew that because Eisenhower was in the military. Most people that I know who were in the military, who had any workings with jurisdiction and having the responsibility of knowing and understanding jurisdiction, they all know this. I guarantee you that all attorneys working for the military understand the Constitution is the federal authority over the federal lands. They all know that. Most of the people that I worked with in the military understood this. I ask people today who are in the military, the young, if they're being taught that the federal government only has authority over the federal lands, and I'm constantly being told no. So these instrumentalities working along with the military and the federal government do not want people to know these days, or probably since the Civil War, that the federal government's laws and constitution apply only on the federal lands. During the time when Kennedy was taking office, Eisenhower was said not to really like Kennedy too much, because Kennedy was going to basically make the White House and the government a comedy act, because he was so young and he was sort of a playboy. Him and his brother were playboys. But Eisenhower was very smart, and he tried not to let his emotions get the better of him. And so he asked to meet with Kennedy, and Kennedy agreed. And they went to, I believe it was Camp David, after Kennedy was sworn in, where Eisenhower explained to Kennedy exactly what the military-industrial complex was and what it was doing, and the fact that it was trying to overtake the entire country to corrupt itself into an absolute power. Kennedy then knew, and because he knew, he came out with his speech on secret societies and was consequently murdered. So constituted a step toward fulfilling the hope expressed by the president in a letter dated April 27, 1956, that's Eisenhower, to the Attorney General, that General Services Administration establish a central source of information concerning the legislative jurisdictional status of federal properties. An interagency committee consisting of representatives of Department of Justice, Bureau of the Budget, and General Services Administration was formed to maintain a continuing and concerted interest in the progress made by federal agencies in adjusting the status of their properties. This committee requested that Administrator of General Services to compile a second inventory on the jurisdictional status of federal areas within the states as of June 30th, 1962, and that is this report that we're reading. The committee deemed the new inventory necessary in order to refine legal determinations in the original inventory as of June 30th, 1957, and further to include data on federal holdings in the new states of Alaska and Hawaii, as well as new acquisitions in other states. And that's because some states did not sell the lands to the federal government. They simply allowed the federal government to use the lands, and that's such as Alaska and Hawaii. Article 1, Section 8, Clause 17. I didn't realize this section by myself. I realized what this section meant because it was written about by Eisenhower. It was written about in documents from the 1900s. Early 1900s, it was written about even in the late 1800s. A lot of people understood at the time even what Lincoln was doing, and that what he was doing was outside the Constitution, was an illegal act. The reason why you won't hear most people talk about it today is because if the federal government contracts too quickly, it could be detrimental to the economy of the entire nation. So because I only have a few subscribers and most people don't understand this stuff, to me, I feel like even though I'm telling you the truth and I'm telling you what is going to contract the federal government is your understanding of this, it's not like people are rushing to my YouTube channel and understanding the information and sharing it and talking about it which is a little disturbing, but at the same time, I guess could be taken as a good thing because the economy is not going to contract too quickly. However, some people believe that because the federal bank has come out and said it was going to start reducing the debt starting in May, that is going to allow for an expansion and a contraction at the same time, and that the economy won't suffer as badly as they would have if they were contracting without paying off the debt. So all the money that's going to be coming in, all the fake Federal Reserve legal tender that's going to be coming into the country as a result of countries moving away from the dollar and going towards a more gold and silver based currency, that money is going to be used to pay off the debt. And as the debt is paid down, the country is allowed to expand but also contract. To exercise, this is Article 1, Section 8, Clause 17 of the Constitution. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may by cession of particular states, and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, such as like authority, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. And those needful buildings and forts, magazines, arsenals, etc. are posts. Those are the military posts. Dockyards, okay, for Navy. It is well known that under the first portion of this constitutional provision, the federal government exercises with respect to the District of Columbia all those powers, judicial, executive, and legislative. So it has the rights over the seat of government. The judicial, the executive, and the legislative have the rights over the seat of government to make laws, to administer justice, to have the executive power, which under our federal state system of government are ordinarily reserved to the states. It is not so well known that under the second portion of this constitutional provision, the portion that has been emphasized above, the federal government has acquired like authority with respect to numerous other areas within the geographical confines of the states and with respect to residents of such areas. So this means that the federal government has the right over the federal lands that it is acquired from the states. That these lands are like confined, geographical confines, they're islands in the state. And that with respect to the residents of such areas, that they have like authority over them, like authority such as what they have at the seat of government. So the authority they have at the seat of government, they also have on their federal areas in the states called posts. These other federal areas, sometimes called enclaves and also islands, are in effect federal islands surrounded by state territory. This would be the Republic of Texas. Federal islands would be state of Texas. State of Texas gave the land to, Republic of Texas is an independent state. As an independent state, it has the right to sell its own lands. It sold its own lands to the federal government to create federal islands, which all those islands together create state of Texas. Just as the British government owns colonies all around the world, and all those colonies together are known as British colonies. They're under the Britain's government, the British government. So these federal islands surrounded by state territory, to the extent that jurisdiction over or thereover has been surrendered to the federal government and accepted by the federal government, the states are then deprived of the ordinary authority of a state and cannot, with respect to the federal areas or to their inhabitants, which are their residents, which are not inhabitants of the state because they're inhabitants of the federal areas, which is important to understand because these places are the federal posts. The posts are the military areas. The military areas are federal states, and the inhabitants of the federal states have to be inhabitants, have to be on the military lands for 7 years to be a representative, 9 years to be a senator. So there you see that the federal areas called islands in the states, which are for defense purposes, which are for the members of the military officers, are inhabitants of the federal islands, the military areas, and they have to be there for 7 years to be a representative and 9 years to be a senator. There's not very many people who have served in Congress under this law that have met the actual residency requirements, being a federal inhabitant on federal lands in the military, that actually can serve as a representative or a senator in Congress. They don't meet the requirements because they've never been in the military. Enclaves, or to their inhabitants, exercise usual state functions, but while the Congress has legislated complete civil and criminal codes for the District of Columbia and provided the local machinery necessary for the administration and enforcement of those codes, it has legislated little and provided little by way of local governmental machinery for such federal enclaves or their inhabitants. Over the years, the peculiar legal status of federal enclaves has given rise to many serious problems. So if you're not on federal lands, you don't work for the federal government, you're not a civil servant, and you're not a military member, then you are a civilian, an inhabitant of the independent state. A civilian is not under the federal Constitution when they are not on federal lands. This means that an entire alternate government, sort of a Jekyll and Hyde situation, has been created for the regulation of civilians outside the Constitution. So it has created itself into a new government to regulate civilians not on federal lands, which is outside the Constitution. They're going to probably keep telling you some sort of thing in the Constitution that looks like it gives the right to regulate people off federal lands, but if that were the case, then you might as well just say all the people of the entire nation can be regulated by the federal government. You wouldn't have to create an entire section in the Constitution saying what you're going to do and where you're going to do it, and that these lands have to be given to the federal government or sold to the federal government, and that the authority to make law has to be sold or ceded to the federal government. They wouldn't need to do that if the federal government had authority over everyone, everywhere. This again was Lincoln propaganda, this idea that people are the government or that the people are regulated by the federal government. This is Lincoln era propaganda. In the past, such problems were handled on a case-by-case basis In December of 1954, upon the recommendation of the Attorney General and with the sponsorship of the President and the Cabinet of Interdepartmental Committee, was formed to study the entire subject of legislative jurisdiction of the federal government over areas within the states to make recommendations thereon. So again, in the report put together by a committee under Eisenhower's direction, printed in 1956 and 1957, a whole bunch of people came together with all kinds of information, including what land they owned, what they had authority over, what they didn't have authority over, what kind of authority they had, what kind of authority the states retained for themselves over those federal lands. They had to come together and put all this information together. So some people believe still, after all my videos, that the federal government has authority over everyone, everywhere, all the time. And this is just not the case. This is how you make sure that people like Julian Assange stay free, that Julian Assange is never put in prison by the United States again, because it doesn't have authority to. This government is corrupt. It's just horribly, terribly corrupt, and it's willing to kill people in order to keep its power, when really all people need to do is understand that the Constitution is not what they think it is, to accept the truth and to be okay with accepting the truth, because accepting the truth is fact, logic, and wisdom. Okay, so we go back to the report. This is what it's saying here. It's talking about this report put out during the Eisenhower administration, where they had to put all this information together, and it included like the Department of Justice, the attorneys of the states, and many other people to put all this information together by these few people that collected all the information. So all these departments had to give the information, and then these few people who wrote the report put all the information together. And as a result came the requirement to do this inventory report, as well as each jurisdiction over each portion of land. The extension of the federal government's jurisdiction over lands within the states and over the residents of such lands was slowed down with the removal of February 1, 1940, of the federal statutory requirement originally enacted in 1841 that, in the case of purchased land, the consent of the state to such purpose to be secured prior to the construction of any federal building thereon. So originally there was a law saying that the state had to give jurisdiction over the federal area, which is power over the federal area. Then they removed that in 1940. And you can kind of see that in 1940 it was written a little oddly. The wording of the law, the actual law on the books, is written really weird. It's like it's saying we have to get the state's authority, and then at the end it says all this stuff, and then at the end it says, but we don't have to have the authority. It only makes sense to make sure that you actually own the land before you build something on the land. In the case of purchased land, the consent of the state to such purpose be secured prior to the construction of any federal building thereon. The acquisition of jurisdiction by the federal government was further slowed down with respect to newly acquired lands by the findings of the above-mentioned committee. However, there does not now exist any administrative machinery for canceling the legislative jurisdiction previously acquired by the federal government from the several states. So that's like saying every way out or every way in has to be written a way out, and here they're saying that they had no way out. They had no way for canceling the legislative jurisdiction, so a law had to be passed. But of course, Congress is not going to pass a law because not passing the law helps them retain more power that they shouldn't actually have. 3. Objectives. The Interdepartmental Committee for the Study of Jurisdiction over Federal Areas within the states made the following conclusions and recommendations. In the usual case, there is an increasing preponderance of disadvantages over advantages as there increases the degree of legislative jurisdiction vested in the United States. With respect to the large bulk of federally owned or operated real estate or real property in the several states and outside the District of Columbia, such as the Post, it is desirable that the federal government not receive or retain any measure whatever of legislative jurisdiction, but that it hold the installations and areas in a proprietorial interest status only, with legislative jurisdiction remaining in the several states. So these would be like some of the federal buildings, the CDC, IRS, FDA, and many of these other places. Not the Post. It is desirable that in the usual case, the federal government receive or retain concurrent legislative jurisdiction with respect to federal installations and areas on which it is necessary that the federal government render law enforcement services of a character ordinarily rendered by a state or local government. So it's saying it should obtain and retain its own law enforcement services, as opposed to them having a standing army off their federal lands. These installations and areas consist of those which, because of their great size, large population, or remote location, or because of peculiar requirement based on their use, are beyond the capacity of the state or local government to service. The committee suggests that even in some instances, the receipt or retention by federal government of concurrent legislative jurisdiction can, and in some instances should, be avoided. So in some cases, they don't want to have concurrent legislative jurisdiction because of a variety of reasons, meaning they don't want to share lawmaking authority with the state. In any instances where an agency may determine the existence of a requirement with respect to a particular installation or area of a legislative jurisdictional status with a measure of exclusivity of jurisdiction in the federal government, it would be desirable that the federal government in any event not receive or retain with respect to the installation or area any part of the state's jurisdiction with respect to taxation, marriage, divorce, annulment, adoption, commitment of the military incompetent, and descent and distribution of property, that the state have concurrent power on such installation or area to enforce the criminal law, that the state also have the power to execute on the installation or area any civil or criminal process, and that residents of such installation or area not be deprived of any civil or political rights. These recommendations were concurred in by the President in a letter to the Attorney General dated April 27, 1956. The principal objective of preparing this inventory is to provide a central source of information concerning the legislative status of federal properties. Another objective is that of providing a means for observing the progress made by all federal agencies in adjusting the status of their properties in conformity with the recommendations of the above-mentioned Interdepartmental Committee. which is the jurisdiction over federal areas within the state. When it says interdepartmental committee, it's talking about the committee that wrote these reports. This is in keeping with the President Eisenhower's letter of April 27, 1956, asking that General Services Administration, with the Bureau of Budget and the Department of Justice, maintain a continuing and concerted interest in such progress. Source of data. This inventory of jurisdictional status, or the status of their power, is based upon a determination of status by the various federal agencies with respect to the areas under their respective control. These agencies' determinations of power of status were reported to GSA pursuant to GSA Services Administration Circular Number 275, dated July 18, 1962, copy of which follows. I have done many FOIAs to the GSA asking them for the filled out paperwork, which you're going to see here in a minute. It's a blank copy. The paperwork, the filled out paperwork that they gave to these various federal agencies to fill out and send back. And I was told every single time, no. In one way or another, the answer was just no. Data with regard to the jurisdictional status of federal land were obtained by the agencies principally from title papers and other basic documents. The determinations are subject to change through the reevaluation of information now on hand or upon the basis of additional facts that may become known. So in this part, I'd like to just state that when you do some sort of paperwork to register any property that you purchase, and you go and you file it with a federal office that looks like a state office, so anything that starts with state of, like state of Virginia, state of Tennessee, state of Texas, state of Ohio, state of Oklahoma, whatever state of, you're doing business with the federal government, and therefore your land is then being counted as inventory under the federal government, to which it can then regulate. And so you're required to follow quote unquote state and federal laws even on your own federal land. So alcohol distilling, marijuana growing, and all of these things back not so long ago were not allowed even on your private property, because you registered it with the federal government. Scope. This inventory report shows the legislative jurisdictional status as of June 30th, 1962, of lands, my dog's sleeping and snoring, of lands located in each of the 50 states in which title is vested in the federal government or in wholly owned government corporations. It covers, with respect to those 50 states, the same land areas that are covered by the inventory report of real property owned by the United States throughout the world as of the same date. Department of Defense military functions reported only summary data for its land holdings in Alaska and Hawaii. Areas not covered. The whole of the area now constituting the District of Columbia is under the exclusive jurisdiction of the United States. It embraces, except for certain adjustments, the area that was ceded by the state of Maryland, Rockefeller, to the federal government for the purpose of establishing the seat. Okay, this was not Rockefeller. Rockefeller was a different piece of land. For establishing the seat of government and accepted by the government in 1790. This area, the area that was ceded by the state of Virginia for that purpose and likewise accepted, was retroceded to that state in 1846. These two areas together approximated the 10 miles square that is referred to in the first portion of Article 1, Section 8, Clause 17 of the Constitution. However, the District of Columbia as the seat of government involves special considerations not generally applicable to other federal areas. Accordingly, the above-mentioned Interdepartmental Committee restricted its report to those areas that are covered by like authority and did not deal with the District of Columbia. The same considerations have led to the exclusion of the District of Columbia from this report. So then I just wonder who actually owns the District of Columbia. I don't know. Inasmuch as the legislative jurisdiction involved in this report concerns the authority of the federal government in relation to that of a state, this report does not deal with property in the territories or possessions or in the Commonwealth of Puerto Rico. So here's definitions. I'm going to skip this part. Public domain. Unlike the inventory of federally owned real property, this inventory has not been compiled on the basis of whether the land is part of the public domain or is after acquired land. Nevertheless, an explanation of the special status of public domain lands is warranted. The term public domain, as it applies to land within a state, refers to those lands which were acquired by the United States prior to the creation of the state and which are still retained by the United States, such as lands acquired by the federal government by virtue of the Louisiana Purchase. The term has no application to any land in the original 13 states or in Texas, which was an independent state prior to its admission to the Union, and at present has only limited application to land in the states created out of the territory and belonged to the original 13 states. Public domain lands are to be differentiated from so-called after-acquired lands which exist in every state. Much of what was originally public domain is now in private ownership through operation of the homestead laws and other similar laws. Other portions of the public domain have been withdrawn or reserved for military or public uses. A state statute providing the constitutional consent to the purchase of lands by the United States, as opposed to a status directly ceding jurisdiction to the United States, would not operate to vest exclusive jurisdiction in United States over public domain lands, inasmuch as the public domain by definition does not embrace land that has been purchased by the consent of the legislator of the state in which the same shall be. Moreover, in only a few states, such as Arizona, Nevada, and Utah, do the direct cession statutes of general application provide for exclusive jurisdiction in the United States over public domain land that is reserved for public use. Also, in only a few cases, such as that of Yellowstone National Park, has exclusive jurisdiction for the United States been reserved in the enabling act by which the state was created. And as indicated above, the statistical aspects of the report do not distinguish between public domain lands and after acquired lands. Okay, so heads of federal agencies, inventory of legislative jurisdiction over federal areas within the states. It's a memorandum, and you can read this. Agency liaison, inquiries, such and such, so on and so forth. And here's the circular that I was telling you about. This is the document that I tried to retrieve from GSA. I wanted the filled out ones, and I requested by FOIA over 10 times at least, and I was told each time no. These were sent into the areas owned by the federal government to probably the commanding officer or who was overseeing that area, or to the various agencies, federal agencies overseeing land in the states. And they were supposed to fill this out and fill it out for each piece of land, as well as the date of acquisition or their purchase and area in acres and what jurisdiction they had over them, as well as the address of the place. Now, the address of the place you see is a federal address, where most of us nowadays, when we designate what our address is on a piece of mail or what have you, it's designated as a federal address with a zip code. Private property should not be attached to a federal address, in my opinion. So then here's paperwork on the circular, how to fill it out, where to send it, and all that stuff. Code descriptions, it was letting them know how to put in the codes, which we already went over. All these, this is just really instruction manual on how to fill out the form. And of course, like I said, I've requested the filled out forms and was told no, they didn't have them. No, they weren't going to send them. No, I didn't fill out the FOIA right. No, I didn't do this or that, or they didn't know where they were. Most of the time the answer was they didn't know what I was talking about. There are some papers inside the some of the libraries where you can find each of the states, as well as a list of the federal areas in the state and what the acreage is and when they acquired it, so on and so forth. Jurisdictional status of federal land areas. These are the federal areas. So the federal areas are where the federal government has authority and power. And at this point, I can go over the Constitution with you. I've been over it several times. You can watch any of my other videos on the Constitution where I go over various parts of the Constitution, and I teach you how to look at the Constitution so that you can better understand exactly what it's saying, instead of just taking it for granted that whatever someone else is telling you is true. So we actually go over the Constitution, and the one thing that I would go over here are the requirements to be senator or representative are basically the same, except for the age and years of citizenship. So if the United States is the seat of government and the federal, basically the outpost or post, then to be a citizen of the United States, you would have to be on one of those posts. Now, a lot of people would curl their lip up at this, but it says, not when elected be an inhabitant of the state. So they're not supposed to be off federal lands. They're supposed to be on federal lands, and that's shown by a citizen of the United States, a citizen of the federal lands, being on the federal lands and not off the federal lands. So if a person, in order to be a senator or representative, has to have a military status of either 7 or 9 years, 7 for a representative and 9 to be a senator, then why is it that all of these civilians with no military history being elected to sit in Congress? And I would say that that's because those people are acting outside the Constitution and have formed themselves into another or second government for civilians. And civilians are not citizens of the United States. They're maybe they're called U.S. citizens by some play on words or some contractual thing that was written somewhere in some obscure place that nobody can find and nobody really knows what it is. But why are they in Congress, and why are they making laws for us? And most importantly, why are we following them? They're not in a constitutional office. Even if they have an oath to uphold and defend the Constitution, it only applies if you're sitting in an office created by the Constitution. So if these people in Congress are sitting in an office not created by the Constitution, then the oath doesn't matter. And all of the officers sitting in offices as officers, as citizens of the United States, are supposed to have a commission by the president. So do the people in Congress, the civilians, not actually sitting in constitutionally created offices, do they have any authority? Do they have a commission? If they don't have a commission, then they have no power. And I believe that none of them do have any power, and they don't have any power to make any law. And any law created would only apply on the federal lands to the military and the seat of government. It would apply also to their contractors that they hire to do contracts on post, to do work on post. But again, these civilians sitting in office in Congress who aren't qualified to sit there, they could only then follow laws that are outside the Constitution. And so those laws would be titles never passed into law. They would be the non-positive titles, which are not laws. And so we're following them and agreeing to them by contract, because everything that we sign is a contract, and it's a solicitation or an advertisement. So their forms, such as the W-4, is a solicitation or an advertisement to contract with them. And once you start the process of fulfilling the obligations of the contract, such as paying money every month out of your paycheck, then the contract is like solidified. And the positive mark, which is your signature on the paperwork, states that you have just made it a law, because a law must be posited. It must have a positive mark if it's a contract. And once it has the positive mark, the contract becomes the law, and the law is in the contract. Okay, so again, Napolitano's statement was that stated differently. This judge, the Florida federal judge who wrote the injunction preventing the CDC from ordering entities regulated by the federal government to require people to wear masks, the judge found that the CDC is without authority to compel wearing masks on any entity that is owned or regulated by the federal government. So any entity off federal lands regulated by the federal government does not have any authority, does not have any power. These things together are called jurisdiction. Jurisdiction is power and authority to do a thing. And so without the power or authority to do a thing, nobody has to follow it. Nobody has to sign the W-4. Nobody has to do anything that they ask. The FDA, the CDC, and all these things. There are other extenuating problems that arise from not signing the contract. So if a doctor graduates from medical school and wants to practice medicine, he can do so, but how is he going to write prescriptions, and how would somebody fill them if the prescription is not written by a doctor and the pharmacy requires a licensed doctor's signature in order to fill the prescription for the patient? So again, these entities, not part of the federal government, have no authority off federal lands or even on federal lands to order anybody to do anything. And the people on the federal lands have no authority off federal lands. And we saw that in the officer's manual that I read, I think 3 or 4 different portions of the officer's manual, which showed also that the federal officers, the military officers, only have authority on the federal lands. Okay, so that's it for this video. I hope you understand. If you have any questions, like, share, and subscribe. And remember, truth sometimes is difficult to accept, but if you're a truth seeker like me, you love facts, logic, and wisdom. And if you're in search of truth, you're willing to let go of your past opinions, no matter how believable they may be, to get to the truth. Okay, So it's always a good thing to be pointed into the right direction. And this is what I'm trying to do. And this is what Andrew Napolitano is talking about in his video posted today on the Doctors Who Don't Like Lawyers title of his video. So go watch that, and then hopefully you've listened to this video and you've listened to me go on and on and on in it. And sorry it's boring, but a little bit of boredom, I think, for an hour or however long this has been, is well worth it, considering the amount of knowledge you've just gained and the amount of power you hopefully now realize you have, and that the federal government has very little, and what it does have is limited to the seat of government and places purchased. So like, share, subscribe, talk about this to your friends, your family, your acquaintances. Feel free to share my video, leave comments, and I will see you guys tomorrow.